Oyez, oyez, oyez. All persons having business before the Honorable, the United States Court of Appeals for the District of Columbia Circuit are admonished to draw near and give their attention, for the court is now sitting. God save the United States and this honorable court. Case number 21-7046, Luis R. Martinez, appellant, versus Constellis, Triple Canopy. Ms. Farr for the appellant, Ms. Carnell for the appellate.
Good morning, Ms. Farr.
Good morning.
You may proceed.
Okay, thank you. Good morning. Thank you for your time today. My name is Kristen Farr, and I represent the plaintiff appellant, Luis Martinez. Today, we ask this panel to reverse the decision made by the district court and find that the plaintiff has sufficiently pled claims for a hostile work environment and false imprisonment. When looking at the totality of the circumstances, Mr. Martinez states a claim for a hostile work environment. The harassment he experienced was due to his protected classes. He checks off both the severe and pervasive requirements of a hostile work environment claim. The comments regarding his beard were pervasive. His supervisor, Mr. Williams, gave Mr. Martinez a hard time about his beard for approximately 5 years, 2 of which were while he was employed by the defendant.
But you don't, counsel, describe with any particularity any harassment beyond the 3, I believe it was either 2 or 3 instances of comments related to the beard, correct? I mean, you sort of summarize that he was weekly questioned about it, but we don't have a sense from the complaint of the extent of those comments.
Well, those are the examples that he experienced, that his supervisor, Mr. Williams, approached him and made comments like that on a regular basis.
I understand, but in our circuit, you have to have allegations that actually, if true, would substantiate the claim. And sort of generic 1 or 2 examples, not with particular detail, is typically held not to be sufficient to state a claim for the kind of hostile work environment that you appear to be alleging here.
Well, if that is all that occurred, that would be true, but these happened for years, and small offhanded comments, 1, 2, 3 certainly aren't going to rise to the level of a hostile work environment, but this was going on for years, that he would make comments, compare him to other employees, talk about the length of his beard, that he had as a reasonable accommodation. So it's the cumulative effect of these slight comments that add up into a hostile work environment claim.
What term, condition, or privilege of employment was affected by the hostile environment?
Well, he was in a very stressful environment, having to worry about his supervisor always commenting on his beard that he had due to his disability. So he is always on edge whenever his supervisor comes around him. He doesn't have the ability to just do his job as other employees without a disability have, to constantly be on edge and worried about more comments and harassment from his supervisor.
I don't see that statement in the complaint. Aren't we at a motion to dismiss stage and evaluating the allegations of the complaint?
Yes, I mean, that is the stage that we are at. I mean, I believe that the inferences that can be drawn from the allegations in the complaint lead to that conclusion.
Is your hostile work environment claim also related to the facts concerning the unlawful detention, or are those two separate?
No, absolutely, those are together. And that is one of the problems with the district court's decision is it's the comments in combination with the unlawful detention that create the totality of his claim for a hostile work environment. And the district court kind of essentially analyzed those separately. And it's the comments that give rise to the motive there, the reason that he's engaging in this behavior. And then Mr. Martinez, along with one other employee with a beard, were the ones that were not so randomly selected for this drug test in a really peculiar and outrageous manner. It was just conducted contrary to policy in a way that would embarrass him in front of colleagues as he is disarmed, taken through the facility by an armed security officer, which gives the impression that he has committed some egregious act. And then, he's taken on a wild ride through Washington, D.C., downtown Washington, D.C., without being told where he is going. So it's the combination of those together that, on one hand, you have the pervasive comments. On the other side, you have the severe, unjustified drug test in that manner that create the hostile work environment claim.
And you also allege a common law false imprisonment claim. Are you maintaining that there was a threat of force with respect to the urinalysis random testing?
Yeah, I think this case is distinguishable from the Faniel case. Stripping of a weapon is a nonverbal threat. It is part of his identity as a security guard. It's important to understand the environment in which Mr. Martinez worked. This is an environment that values chain of command and strict compliance. Ms. Faniel had a fear of losing her job, but Mr. Martinez not only had that fear of losing his job, but potentially his career, because losing your job for being terminated for cause, for being terminated for insubordination can affect his potential employment elsewhere, his security clearance. And in that way, his situation is vastly different from Ms. Faniel, who was a key punch operator at AT&T. So, there's a distinction there with the manner in which he was taken into the car. He did not know where he was going, whereas Ms. Faniel was aware of where she was being taken and why she was being taken there. And she consented to the trip. She did not consent specifically to picking up the security officer. And it's at that point where the court notes that she did not object or manifest a desire to change her prior consent. However, in this case, Mr. Martinez did not give that original consent. He was stripped of his weapons and escorted out by an armed security guard.
But I guess I'm curious about your view of whether there was a threat of force. I mean, it seems that as though the Faniel case, when it talks about the requirements, I understand the facts are different, but to show unlawful detention or restraint, says the district court, the plaintiff must demonstrate that his movements were totally restrained through, quote, threats of force or by exertion of legal authority, and he quotes Faniel for that proposition. Is that not an accurate statement of the law? And if it is, where is the threat of force or exertion of legal authority in this case?
Well, the fact that he was being escorted by an armed security guard who's essentially acting as, not just the employer, but as a position of authority, enforcing the safety of the building and having that authority to command him to come with him. I mean, even if he said, well, I quit, he's still being detained. He can still be escorted out, potentially by the security guard. So I think it's very different. And yes, you accurately stated the law, and I believe that Mr. Martinez's case falls within that standard.
So let's suppose we agree that there's a detention against his will. You also have to show the unlawfulness of the restraint, right?
Yes.
So what was unlawful about what they did?
There is a specific policy that governs drug testing that was not followed here. There's different reasons that somebody can be drug tested. You can have cause for the drug test if you are giving suspicion that you are under the influence. They can specifically point to you, send you for a drug test. That is not the case here. Alternatively, it can be a random drug test.
Even if I take your point that they violated policy, how does that make his restraint unlawful?
They did not have the authority to do it in this manner, that it is, again, a specific way of treating their employees. This is a collective bargaining agreement, not just a company policy. So it's, contrary to the contract. And
an arguable violation of a contract, which doesn't seem like that's unlawful. There's a difference.
yeah, that's true, yes.
All right, your time is expired. We can give you some time on rebuttal. I'll ask my colleagues if they have any further questions at this time.
No.
All right, we'll give you a couple of minutes on rebuttal. Let's hear from counsel for Constellis Triple Canopy, Ms. Cornell.
Yes, good morning, Your Honors. May it please the court. My name is Susan Cornell, and I'm here representing Mr. Martinez's employers, Constellis and Triple Canopy. We are asking the court, as you might imagine, to affirm the lower court's decision dismissing the amended complaint with prejudice. The appellee has raised 3 grounds of appeal: that he stated a plausible claim for hostile work environment, that he stated a plausible claim for false imprisonment, and that the dismissal with prejudice was improper. And I'll address each in turn. Mr. Martinez has asserted a hostile work environment based on his appearance or disability. But to make out, as you've noted, a hostile work environment claim, there must be discriminatory intimidation, ridicule, or insult that is severe or pervasive so as to alter the terms and conditions of employment and create an abusive working environment. The severity and pervasiveness are supposed to be determined by the totality of the circumstances. Those circumstances include the frequency of the alleged discriminatory conduct, their severity, whether those instances were physically threatening or humiliating, and whether they unreasonably interfere with the work performance. The standard is an objective one, and it's a standard that this court has characterized at times as requiring extreme conduct. Here, essentially, Mr. Martinez relies on frequency alone. None of the specific comments alleged could be fairly characterized as insulting or intimidating or humiliating. He also alleges the circumstance that this was a work rule requiring that his beard be trimmed so that the hairs, quote, not protrude more than 1/4 inch from his face. There is simply no discriminatory insult and injury. Even if we assume that Mr. Martinez's allegation—
Isn't someone who, for medical reasons, appeared in as being harassed on a daily basis about that, even though they are complying with the medical exemption, they're complying with the work rule every day for a 5-year period? Isn't that, I mean, would you want to work under those conditions? Wouldn't that be psychologically debilitating?
Your Honor, we do not contend that there are no set of circumstances under which daily appearance-based or disability waiver-based comments could create a hostile work environment. I certainly agree that they could. I think that the allegations, and I think the record reflects that the allegations identified in this complaint do not support that. The allegations were asking about the length and shape of the beard. There are very few specifics in here. And my point is that if those happen on average every other day, that what we have is a beard that grows, and that it can't be a one and done conversation if the obligation is to demonstrate or to confirm compliance with a work rule where that compliance will always be ongoing.
Counsel, that's not reading the complaint in the light most favorable to the plaintiff, though. That's not how the complaint describes the interactions and the conversations about the beard, is it?
I think the complaint describes two specific conversations with my client, one in which he compares his face to another person, and we don't actually know what he says, and one in which he says, I believe, that he asks for the length and shape of his beard. Those words do not suggest to me anything inherently harassing, intimidating, or insulting. I think that the characterizations in the complaint where the appellant and his counsel call them humiliating or call them harassing are characterizations that need not be assumed true. But I would argue that what Mr. Martinez is relying on is frequency alone. And I would suggest that a long list of trivial incidents is no more a hostile work environment than a pile of feathers is a crushing weight, as this court said in the Baird decision. With respect to the false imprisonment claim, this claim was—
Can I just ask you before you go on to that claim?
Yes.
Ms. Farr also indicates that the hostile work environment claim itself is supported by the additional facts related to what she says was an unlawful detention. Do you have any response to that? In other words, we're not only looking, she says, you said totality of the circumstances, and she has added to the circumstances the incident concerning the urinalysis. Is that
yes, Your Honor,
thing to do, and what is your response to that?
Thank you for raising that. I appreciate that opportunity to add to my argument. We don't believe that drug test constitutes any incident of harassment at all, much less one that could contribute to a hostile work environment. It is a drug test that occurs in workplaces. It was not particularly severe. It's not frequent. It only happened one time. It was not objectively humiliating, although Mr. Martinez says it was subjectively humiliating. It was not threatening. And I would argue it's a perfect example of an ordinary tribulation of a workplace. He actually identifies having been approached in private when no one else was around and being asked to go with Major Rouse. And although he walked through a public location, I don't think we can assume that was objectively humiliating. So I would argue that incident alone would not constitute a single incident of harassment, nor would it contribute to an ongoing pattern of harassment.
All right, so the standing alone then in looking at the unlawful detention claim, what's your argument about that?
Well, Your Honor, I think you all have keyed on the key case, which is the Faniel case, where the court confirmed that in order to have a false imprisonment claim, you needed to have an unlawful detention without consent. And here, Mr. Martinez was not restrained of movement. His restraint was not total at all. He walked on his own volition down through an elevator in a public building. He walked away from Major Rouse and returned. He may have been concerned about the circumstances of what was going on, but he did not express any unwillingness to go. He did not refuse to get in the car. He did not attempt to leave the car. He, in fact, got in the car a second time for the return trip. There's no question that it was, in essence, voluntary, even if he thought that his...
Isn't he responding to a show of authority by a supervisor? I mean, it would have been insubordinate for him to have not gone with his supervisor when his supervisor says, give me your gun and you're coming with me.
I think that it is fair to assume from the facts alleged in the complaint that Mr. Martinez believed his job was in jeopardy or he would be subject to discipline if he did not comply. I think that is absolutely fair to assume from the allegations of the complaint. I do not think that that is sufficient to rise to the level of a false imprisonment under the common law of the District of Columbia. He needed to be subject to the threat of force and to actual force or the threat of force. And I think the complaint allegations make clear that he was not. I think that Ms. Farr's argument today confirms that he was not. She distinguished it from the Faneuil case by saying that Ms. Faneuil was concerned about her loss of job, but not her loss of career. But here, there's no distinction in the allegations of the complaint. Mr. Martinez may have thought he had to go to save his job, but that's essentially identical to the case in Faneuil. I'll also point out...
I'm sorry, can I just ask you about the restraint against his will, though, piece? I mean, do you deny that this was against his will, that he was asked to go or that he went?
I would say from the allegations in the complaint, it is safe to assume he did not want to go, but that he did voluntarily in any event. Just like if your supervisor tells you to do something you don't want to do, you can't claim it's involuntary when you do it. It's not subject to the threat of force or actual force because you comply.
What about false pretenses? What about the fact that he apparently was told, according to the complaint, that he was going to complete a survey and that was not true? Does that play any role in our understanding of whether or not unlawful detention occurred?
I think that the Faneuil case would suggest that it does not convert an otherwise consensual car ride into a non-consensual car ride. Ms. Faneuil understood she was going home, but the court actually addressed the fact that they made an unannounced diversion to pick someone else up. And she made the argument that she had not consented to that unannounced diversion. And the court said that was not sufficient. She made no effort to get out of the car and she made no effort. She made no vocal objection. Here, I would argue Mr. Martinez actually went without knowing the nature of the survey, which, I don't know exactly what was said. We know that in that complaint, it's alleged that he was told it was a survey, but he went not knowing what that meant. And I would argue that makes his consent to get into that car as he walked hundreds of feet down the hallway even more consensual than that for Ms. Faneuil, who thought she was being only driven home. I would also say that although Ms. Farr argues that the complaint says that Major Rouse was armed, I don't actually see that in the complaint itself. And we don't know from the Faneuil case whether the security officers from CMP Telephone or AT&T were armed. I just don't know that we can assume that they were not. I also think that it would be a troubling extension of the false imprisonment law to assume that because one party is armed, even if we're going to accept that argument, and one party isn't armed, that necessarily implies a threat of force. And I think that would greatly expand the law of false imprisonment to a point beyond which the law permits. Lastly, I would just argue that this was an appropriate use of a dismissal with prejudice. Mr. Martinez had already had an opportunity to amend his complaint. And so this is not an initial amendment. And also, Mr. Martinez and his counsel did not at any point before the district court ask for an opportunity to amend the complaint a second time, nor have they at any point in this proceeding identified additional facts that they could use to bolster any of their claims. At this point, I think that what they're arguing is the district court should have been obligated to offer a third bite at the apple without being asked. And I don't think that either Rule 12b6 or Rule 41 would make such an obligation required. For all of these reasons, we ask that the decision of the lower court be affirmed in total.
All right, thank you, counsel. Ms. Farr will give you 2 minutes in rebuttal.
Thank you. Just a couple points. With regard to the employer's right to monitor the accommodation, this monitoring is visual. It would not require constant commentary by Mr. Williams to see whether or not the beard is too long. And if the beard is out of compliance, Mr. Williams could privately speak to Mr. Martinez, document the issue, re-engage in the interactive process if necessary. Asking a clean-shaven employee for input on Mr. Martinez's appearance is inappropriate. In the same way, if a employer commented on an employee's short skirt and asked another employee to take a look at that, consider that, even if there's a dress code policy, that would still be sexual harassment. This visual monitoring could have been done without the constant comments. Also, the ordinary tribulation with regard to the drug test, all they could have said is, we need you to take a drug test. There are facilities in the building that could have done that. There's no reason to go on this crazy ride through DC under false pretenses. Just say that you need to drug test the employee, that you have the ability to do that. And I believe that this complaint, as written with inferences in the favor of the plaintiff, state a claim for these allegations. But I will note that, the amended complaint, the original complaint was pro se. There was only one complaint drafted by counsel.
Does that really matter, though? It seems to me that the issue is not who drafted the first complaint, but the fact that the district court wrote an opinion with respect to the first complaint and said very clearly that he was concerned about the allegations that the pro se plaintiff had made. He laid out, you need to say more about these incidents, you need to comply with the requirement that they be frequent, etc. And to the extent that then the amended complaint comes in, drafted by an attorney, but does not, in fact, say much more, why isn't Ms. Cornell correct that this plaintiff should not be given a third bite at the apple related to this?
Well, I think that this, and that's why, we filed the appeal, because I think this complaint does address the court's original concerns with regard to frequency and, really gets into the detail of the unlawful restraint and that element that was really not fleshed out in the original complaint. So I think that the complaint
in fairness, the unlawful restraint wasn't in the original complaint, right? It wasn't a second claim in the original complaint.
True. I also mean with regard to it being an element of the hostile work environment claim that was really fleshed out in the amended complaint that wasn't in the original pro se complaint.
All right. Well, thank you, counsel. We will take the matter under advisement.
Case number 20-5179, Gulf Restoration Network et al. Appellants versus Debra Haaland in her official capacity as Secretary of the Interior et al. Ms. Hardy for the appellants, Mr. Heminger for the appellees.
Good morning, Ms. Hardy. You may proceed.
Good morning. May it please the court. I'm Brittany Hardy for the Conservation Group Appellants. I'd like to reserve 2 minutes for rebuttal. The environmental impact statement that we've challenged is the last chance for the Bureau of Ocean Energy Management to evaluate the environmental effects of offering millions of acres of public land for oil and gas development. And it's important that the agency gets it right. It matters. Here, the Bureau didn't get it right. Instead, the EIS for the 2 lease sales contains false assumptions that misled the public about the true risks of the sale. I'd like to talk about 3 stark errors with the agency's analysis that warrant vacature. First, the Bureau skewed its analysis about whether to hold these lease sales and instead treated the decision as a foregone conclusion. Second, the Bureau relied on the existence of brand new safety regulations to conclude that another catastrophic spill wouldn't happen when it was well aware that Interior was in the process of dismantling those same regulations. And third, the Bureau promised commenters that it would analyze substantial enforcement shortcomings that the GAO had identified. But in its analysis, it didn't even consider those gaps. So turning to the first claim, which is the Bureau's skewed no action alternative. Here, the agency improperly assumed that the effects of the proposed lease sale would happen eventually, whether or not they decided to hold those sales. And that completely skewed the agency's analysis of benefits and costs and affected its decision, led to an arbitrary decision.
Ms. Hardy, I was confused as to why in your brief you didn't cite to or focus on the Interior's assessment of a no action alternative in the programmatic EIS. I didn't see that in your brief, and I'm just wondering why that is.
Well, the no action alternative from the programmatic analysis can't substitute for the decision that the agency was making at this stage, the lease sale stage. So at the programmatic level, the agency was deciding whether or not to hold lease sales at all. And that's a different decision when you get to year 2 or 3, and you're deciding whether to hold an individual lease sale. To give a practical example,
if the first EIS assesses the broader question, why can't the second EIS zoom in and focus on the marginal effect of the 2 lease sales directly at issue at the later stage?
Well, first, the second EIS didn't zoom in. The second EIS didn't look at the question of whether to hold those lease sales. It assumed that the lease sales would happen eventually. Later lease sales would make up for those effects.
But it assumed that in the context of the programmatic EIS and the evaluation that the agency had made, that they were going to make a certain number of lease sales during this 5-year period. It assumed that in context. It wasn't in the air that they thought, okay, if this lease sale doesn't happen, another one will, because that determination was made at the programmatic stage. So I'm curious, as Judge Katsas is, as to why you didn't really assess the fact or challenge the fact that the programmatic EIS did the assessment of no action, meaning no lease sales during this period of time.
Well, the question is different at the lease sale stage. So it's important to understand at the programmatic level, they set a schedule to hold 10 lease sales. And if they don't hold these 2 lease sales, that means there will be 8 lease sales instead of 10. It doesn't mean that those lease sales will happen later. It means there will be a lower number of lease sales. And that matters because if there are less lease sales.
Can I just, I don't understand. The initial stage is where they say we're going to hold 10 lease sales. So when they get to the later stage and they're assessing a particular lease sale, why is it unreasonable for them to say, even if we don't do this one, that is the no action alternative in this context, there will be another one because we have previously determined that we're going to do 10 during this period of time. That's how I read these documents. You seem to suggest that they could say at the second stage, if we don't do these, we'll just have 8 now. And I'm suggesting that they had previously said, no, we're going to have 10 regardless.
Well, the fundamental, I guess what's important to understand here is that the programmatic stage, they did not commit to holding 10 lease sales. So, and the agency isn't arguing that it committed at that stage. The underlying statute, the Outer Continental Shelf Lands Act, doesn't require the agency to hold all the lease sales in its schedule. And in fact, in the past, the agency has decided not to hold all scheduled lease sales. So the programmatic level is just setting a tentative schedule. It's not committing to those lease sales. At the lease sale stage, and if you look at the purpose that they articulate in the lease sale EIS, the purpose of that process was to decide specifically whether and how to hold these lease sales. And so the question of whether to hold this lease sale was made, the commitment was made at the lease sale stage. And that's at JA 859. So just to give a practical example, if you were looking at your retirement investments and you decided, I'm going to sell 10% of my investments once a month for the next 10 months. And then you moved forward, January and February, sold 10% of your investments. March, you said, I want to relook at this decision and decide whether to sell 10% of my investments. The decision at that stage is much different than deciding whether to sell all of your assets writ large. It's a question of whether to sell your assets in that month. And you couldn't just assume that you would double up and sell 20% of your assets in April, because that's a different decision-making process. You may decide to do that, or it's equally as likely that you may not double up and you may not sell any assets in April. But the agency here improperly assumed that all the effects from selling 8 lease sales would be exactly the same as if they had sold 10.
In the interest of time, you may want to move on to your second and third arguments.
Sure. In terms of the safety regulations, I want to step back and just put this in context. We had the Deepwater Horizon spill just a little over a decade ago. And now the Bureau is saying that everything is fine. All the problems have been fixed. So we don't need to worry about going full steam ahead with oil and gas production. But the record tells a different story. Interior was dismantling important safety regulations, and evidence shows that reforms hadn't been made.
I think the problem I see with that argument is that at the time, those regulations had not been amended. And so I don't see how you can have an agency in an EIS assume that regulations are going to be changed when they haven't been changed yet. And then further, the changes that were made didn't completely dismantle them. They changed some of the requirements, but they weren't completely dismantled. I'm more interested in your argument about enforcement assumptions, given the results of the commission that examined the Deepwater Horizon spill and the GAO findings.
Sure. Yes. So to answer your questions about the safety rules, NEPA requires agencies to look at impacts at the earliest possible time. And these rule repeals were well underway by the time the agency completed its EIS. The administration had issued 2 executive orders directing Interior to dismantle these rules. The Secretary of Interior had also issued an administrative order telling the agencies to do the same. And days after the agency completed its EIS, the Interior had sent proposed rules to the OMB and had published proposed rules in the Federal Register. So this was not a crystal ball inquiry. This was information that was available to the agency. And it's important to remember that in the environmental impact statement, the agency gave false information. It told the public that these rules were not changing. At the very least, it needed to acknowledge that these changes were underway. And it relied on these rules specifically to prevent a catastrophic spill from happening, which is the very—
Ms. Hardy, didn't it rely on other things as well, so that even if we agree with you that these two rules were under revision, that it was clear as to how they were being revised, that they were being revised, and the agency should not be able to close its eyes to that with respect to the EIS, in this particular circumstance, I had understood the agency to rely not only on those rules, but also a statistical analysis and other safety regulations in making its determination that a catastrophic oil spill was unlikely. So what do we do with that if there is, say, a problem with their reliance on one aspect of the record, but there are other things in the record to support the conclusion?
The agency relied primarily on these safety rule changes, particularly the well control rules. So at JA 369, the agency said a catastrophic spill is not expected, partly given the extremely low probability, the quantitative analysis, but more importantly, as a result of the reforms put in place after Deepwater Horizon. And the agency goes on to say that these reforms would help ensure that the U.S. can safely and responsibly expand development. The agency also specifically said at JA 1018, finalization of the well control rule was expected to decrease the probability of deepwater blowouts. So the agency considered these reforms to be the most important part of its conclusion that a catastrophic spill wouldn't happen. And turning to the Judge Wilkins's question about the substance of the repeals, the Interior Department was removing critical requirements. For example, the agency was removing requirements to close a blowout preventer seal at all times, and removing requirements to ensure that the seal closes properly. And the blowout preventer, remember, is the equipment that failed during Deepwater Horizon. The revisions also eliminated standards for third parties inspectors to remain independent. And that was something the Deepwater Horizon Commission identified as critical. So these were not minor changes. These were removing important requirements that were needed to address Deepwater Horizon. When the agency was putting these rules into place too, the agency stated in the proposed rules that one consistent element in the Deepwater Horizon investigations was that additional requirements related to blowout preventers and well control equipment are needed. And a primary purpose of the well control rule was to do those things. And that's at 81 Fed Reg 21508 and 25890. I can turn to the safety enforcement claim, Judge Wilkins, that you alluded to in the GAO report briefly. In the GAO report, the GAO identified substantial failings with the Safety Division of Interior's enforcement and inspection program. And the Bureau, in its environmental impact statement, when it was doing the programmatic EIS, recognized that the GAO report was a critical issue and told the public it would address those shortcomings and any planned reforms in the lease sale EISs. Then when it got to the lease sale EIS stage, the agency changed its story. It said that the GAO report was outside the scope of leasing and to direct any questions to the Safety Division, another agency. So, and then in its briefs, the agency's counsel changed its story again, saying that what it meant in the programmatic EIS was that the agency was going to address these findings at a later stage. But that's not what the agency said in the EIS. And the agency, this court shouldn't attribute arguments from the agency's counsel that the agency itself hasn't made. Also, that argument doesn't hold water. The lease sale is thus the critical stage. As this court has held, it's the stage of no go. So it was critical for the agency to address these shortcomings now. And as this court has found in Delaware Department of Natural Resources, it's insufficient for an agency in responding to comments to push the issue off to another agency. It must meaningfully respond to comments.
Ms. Hardy,
Otherwise,
I'm wondering whether the GAO report, though, is really all that damning. I mean, is it something that we need to be concerned that the agency didn't adequately take into account because it might actually change its view of how things are going or should be going in this situation? It was somewhat critical of the safety agency, but was that enough to undermine the agency's conclusion that there will be enforcement of these safety protocols in a way that would mitigate environmental impacts?
The GAO report identified significant deficiencies. These weren't just minor problems. So if you look at JA 441 in the appendix, the GAO concluded that the safety division, it terms it with the acronym BESSI's deficient oversight capabilities continue to undermine its ability to effectively oversee offshore oil and gas operations. And at JA 438, the GAO found that the safety division had in fact reversed steps taken to address post-Deepwater Horizon concerns. So what it found was that 7 years after the Deepwater Horizon spill, the Bureau still had not corrected gaping holes in their regulatory enforcement and made the reforms that were needed. These were big problems that needed to be addressed. And remember, the Bureau itself recognized that these were problems it needed to address, but then failed to do so.
In the interest of time here, let's suppose for the sake of argument, we agree with you on one or more of those claims. Why is vacature appropriate here, given the arguments made by the EPA and interveners?
The presumption in this circuit is that if an agency makes an arbitrary decision, this court should vacate that decision. This is not the rare case where the court should remand without vacature, because here the errors the agency made were serious. They go to the heart of NEPA. What the agency did was undermine public disclosure, which is a fundamental requirement of NEPA. And it undermined decision-making. One of the most important questions in an NEPA process is whether or not to take the proposed action. Remember too that this was—
You don't disagree that you're not saying that in every NEPA case, there should be a different rule. You have to vacate in the NEPA case, but in other APA cases, you can remand without vacature. You're not saying that, are you?
No, I'm saying that the ordinary remedy for an arbitrary decision is to vacate that decision. And the court has discretion to depart from that ordinary remedy in rare cases, but it must balance the seriousness of the agency's errors with any disruptive consequences if it is going to exercise its discretion to depart from that ordinary remedy. Here, the errors are serious, so they don't warrant remand without vacature. And keep in mind too, this is not a decision to build a highway. This is a massive decision about whether to open all available land in the Gulf of Mexico to oil and gas leasing. And these errors go to the heart of these operations. After Deepwater Horizon, there couldn't be a more important issue to get right than whether or not there should be a catastrophic spill and all the devastating consequences expected. It's important for the agency to look at that risk and evaluate those impacts in full before it makes its decision. And here the agency didn't do so. So it's important for the court to vacate this decision so they can start from a clean slate and get it right.
What of the economic impacts that the interveners and the EPA identify and the disruption?
The destructive consequences here are limited. This court has held that destructive consequences alone, first of all, shouldn't be a basis for declining to vacate. They have to be considered in the context of the errors that were made. Here, the only information that we have about economic disruption is that the oil companies have made payments to buy leases and rental payments. We don't have any specific evidence of reliance that the industry has placed on these leases or drilling that has started or expenses related to drilling. So we're really just talking about refunding money here. That
I mean, the intervener says we'd have to, if the leases were in effect vacated and then they had to be bid out again, we're in a situation where now the public knows, what the winning bids were. And so you can't really kind of put the toothpaste back in the tube and have the same sort of bidding process.
Well, the industry, first of all, placed its bids with knowledge that these lease sales were under challenge. The result, too, is not that these companies can't bid in the future. If the Bureau decides to reopen this lease sale, the companies are able to bid. They may have to pay slightly higher prices, but that competition happens all the time in this area. That's a minor effect compared to the bigger NEPA errors that are at stake here and the importance of getting this analysis right.
Judge Jackson, Judge Katsas, do you have any other questions at this time?
No, thank you.
All right, counsel, you're over time, but we'll give you some time on rebuttal. Let's hear from counsel for the department, Secretary Haaland, Mr. Heminger.
Good morning, Judge Wilkins, and may it please the court, Justin Heminger for the Department of Interior and Federal Appellees. Before deciding to hold 2 lease sales in the Gulf of Mexico in 2018, Interior's scientific and technical experts did an extensive and deep dive into the potential environmental impacts that would come from leasing. And it documented those potential effects in 3-tiered environmental impact statements. Because Interior's analysis complies with NEPA, this court should affirm the district court's judgment. I'd like to cover each of the topics that we've heard today, starting with a no action alternative, addressing the safety rules, also addressing the safety agency's role in enforcement, and finally addressing remedy. So turning first to the no action alternative, I think it's helpful to take a step back and orient the court to the statutory program here. This is under the Outer Continental Shelf Lands Act. OXLA has a 4-step process that it applies for leasing. But the express policy that Congress has established here is to make the shelf's resources available for expeditious and orderly development, subject to environmental safeguards, keeping in mind the nation's interests. So at the first stage, Interior is setting up a 5-year plan for leasing decisions. That plan is not, in fact, a commitment, which I think was one of the court's questions. It is a plan. So it is a schedule of proposed leases, but it doesn't mean that Interior is, in fact, going to do each of those leases exactly the same when it comes time for those leases. At the 5-year.
Sorry, Mr. Heminger, does it mean that it will do those leases, though? I mean, the most interesting part of Ms. Hardy's argument, from my perspective, is the revelation that even though the plan said 10 leases, she indicates that that doesn't mean that the agency will ultimately have 10 leases during that time frame. Is she wrong about that?
No, I agree, actually. I agree with the appellant's counsel. She's correct. The fact that there is a schedule of 10 leases does not mean that Interior is going to do each of those leases. So the decision at the 5-year stage is to plan. So to be clear, what Interior cannot do is, after scheduling, and here it was 10 lease sales over a 5-year period, Interior can't then add an 11th sale to that 5-year period. So it can't expand or change the go outside the scope of that 5-year plan. But within the 5-year plan, decisions about how many leases and what those leases look like are made at the second stage.
Okay, so she says at the second stage now, you've gotten there, you
Yep.
have these 2 leases, and to the extent that you are required to assess a no action alternative, why is it enough to essentially say, well, if we don't do these 2 leases, we're going to do other leases per our original plan?
So I think there are 2 things that are important to understand here. First, it is still relevant that at the first stage, Interior did look at the no leasing in the Gulf no action alternative. That no action alternative is relevant because Interior tiered to and incorporated that same no action alternative when it reached the leasing stage. So at the second stage, Interior didn't ignore the alternative of no leasing at all in the Gulf of Mexico. It just said, we've done that analysis, we've incorporated that by reference into this analysis at the second stage.
But I hear Ms. Hardy saying it's actually a different analysis at the second level.
It is, and I.
Okay.
So I would agree. Yes. So there's again, it's sort of a pyramid process, and so you're filtering down. And I think Judge Katsas referred to this as zooming in. So at the second stage, when you zoom in to the lease sale stage, what Interior is looking at is the proposed action, the proposed decision to do a single lease sale. That's the question that Interior is looking at. And so what it needs to determine is, what are the environmental impacts of either doing a single lease sale, canceling that lease sale, or in fact, doing something that's in between those 2 options. All options are on the table. Interior has the full menu of options in terms of how much leasing it does at that lease sale stage.
All right, so when it's looking at the no action, cancel that lease sale, what
Yes.
are the relevant criteria? And does it make sense for them to say something about, well, this is going to happen anyway?
Yes. So here's where I think the plaintiffs are simply incorrect and wrong about what Interior's analysis shows. We're looking at 2 different categories of effects. NEPA says you look at the direct and indirect impacts of the proposed action. That's the primary analysis. But the second thing you look at is cumulative impacts. And cumulative impacts are what happens from other actions that are not the action that you're actually looking at, proposed action. So what Interior does at the second stage, and this is documented in 2 EISs, it's the Multi-Sail Eis and the Supplemental Eis. What it says is, look, the effects of the direct and indirect impacts of holding this sale are a comparison between a baseline, a no action alternative, and holding that sale. But let's look over here at what's going on in the OXLA program as a whole. This is a program that Interior has administered for decades. It has a 5-year plan in place. It expects to do more 5-year plans in the future. What are the cumulative impacts, the effects of leasing that has happened, that is ongoing, and that will happen in the future? Those cumulative effects are what Interior refers to when it says, look, if we cancel 1 sale, that doesn't change the overall impacts, the cumulative effects of what is going to be happening, what has happened, what is happening, and what will happen, reasonably foreseeable in the future. Those cumulative impacts are what we expect to happen. That's a reasonable judgment. It's a prediction by Interior based on its experience and its deep knowledge of leasing and its administration of a program that Congress put in place decades ago.
But doesn't it presuppose that when you do the broad assessment at the early stage, which is, let's just say it's 10 versus 0, and you get your plan and you say, we think we'll do 10. I understand there's no final commitment, binding legal obligation to do all 10, but isn't there some understanding that that's what you're intending to do, likely to do, presuming to do? Because if not, then I don't understand why at the second stage you wouldn't have the 10 versus 8 question be completely open, and the no action alternative would be that there are 2 leases before us. We're not committed to doing anything else, so we have to assess 10 versus 8.
No, that's exactly right, Judge Katsas. There is a plan here to do 10 lease sales. The final decision to do those, whether to do each of those sales, happens at the point of the sale. Yes.
Okay.
So, but keep in mind, this is a program, Congress put this program in place, and the program is to do expeditious and orderly development of the shelf. And so what Interior is looking at, and the cumulative impacts analysis, the best place to see that is at JA 939 to 942 and JA 950 to 951. But Interior talks about how it's looking at energy demand, it's looking at the OXLA program, and it's forecasting based on its experience with leasing in the Gulf of Mexico for many decades. It's forecasting that it's reasonably predictable that leasing will continue into the future. And plaintiffs call that a false assumption, but that's based on Interior's expertise. It's based on its judgment. And this court's decision in Village of Bensonville, VFAA, says when you're defining a baseline and then you're looking at the way to predict the future, that when you're defining a baseline, it's really an expert judgment by the agency. So
in light of the plan.
Correct.
Okay.
Correct.
Can you speak to the other 2 issues? I'm mindful of your time.
Yes, Judge Jackson. So on the safety regulations, I wanted to highlight the point that you had asked counsel for the appellants, which is Interior's primary conclusion here about the risk of a catastrophic oil spill is based on a technical and statistical analysis that it did. And that is in the program EIS. The joint appendix sites are JA 289 to 291 and JA 371. 289 to 291 and JA 371. And Interior's conclusion from that, so that analysis in that risk assessment is based on data that comes from 1964 to 2014. So it includes data that pre-existing the Deepwater Horizon disaster. And it doesn't even, and that data doesn't include or account for the 2016 safety rules that are at issue here. But Interior's conclusion from that data-driven analysis is the risk of a catastrophic spill is very low. In fact, it's so low that it's not a reasonably foreseeable result or occurrence in the context of these lease sales. So that's Interior's conclusion, and that's the basis, the record evidence that supports that conclusion. Plaintiffs simply overlook that and focus on the 2016 rules and the amendments.
What is your argument about the rules? Because I guess I'm a little concerned about the suggestion that if the agency is in any way relying on rules that are under construction, so to speak, that it has flagged as being subject to amendment, that the proposed amendments are out there, that we, according to Ms. Hardy, have executive orders saying we're going to change these particular rules. I guess I'm concerned about the suggestion that the agency doesn't have to take that into account if it relies on those rules when it's putting together an EIS. So is that your position? Are you taking the sort of hard line, unless the rule is in effect, we don't have to look at it?
No, Your Honor, and I don't think the court has to draw a bright line test here between based on legal effect. I think that's a relevant consideration. Are these rules that are in effect because as we all know, a proposed rule can change. So there's not, there is a certain amount of uncertainty there, but I don't think you have to agree that somehow releases the agency from any obligation to consider the issue. I think more importantly here, the plaintiffs are really exaggerating the amount of reliance that Interior was placing on these 2016 rules. So plaintiffs try to suggest that the 2016 rules encapsulate all of what Interior was relying on in deciding that the risk of a catastrophic spill was very low.
Here's my problem with your argument, counsel, is that there was a catastrophic spill in 2010. So who cares about the statistics? We just had one. And we had a report by a commission that focused in on that catastrophic spill and said that one of the key reasons it happened was because of lack of enforcement and basically agencies not really taking their NEPA obligations seriously. And then rule changes are promulgated in response to that catastrophic spill to try to keep it from happening again. And then you're going to argue to me that undoing those rule changes is kind of a nothing burger, and a GAO report that says that the agency isn't really effectively enforcing the old regulations, let alone any new regulations and procedures, is really something that should just, not really take any serious role here in the EIS after we've had a catastrophic spill that did devastating damage to the environment and decimated lots of livelihoods from people who make their living on the Gulf. You're really going to make that argument this morning?
No, I wouldn't, Your Honor. I wouldn't dare to. And I would say Interior's reforms after the Deepwater Horizon disaster, and it talks about this throughout these EISs. Interior undertook the most serious reform in the department's history, and those reforms are not solely the 2016 rules. Those reforms covered many other areas and other rules, and I think at JA 245 to 246, Interior had laid out a listing of the comprehensive reforms that it included. And one of those reforms is the well control rule. And Interior certainly saw that rule as an important safety measure. But to be clear, we're also not arguing that we also completely disagree with the notion that Interior repealed or dismantled the 2016 safety rules. As Interior explained in several places, it made targeted amendments, revisions to those two rules. It didn't dismantle them, or as the plaintiffs say in their reply brief, repeal them. Those rules, the substance, the core of those rules, and the environmental safeguards, the important environmental safeguards that those rules provided are still in place. And that's reflected in Interior's analysis at Joint Appendix 1058 to 1064. That's a fact sheet going over the revisions to the well control rule. And then to the extent, so this issue, Interior did acquire more information later in the NEPA process.
Why wasn't it addressed really head on and in a straightforward way in the supplemental EIS?
So what Interior said there,
rather than rely on enforcement to say, well, we're not going to have any catastrophic failures, and then you're going to rely on that, but you're not going to address head on the systemic failures at enforcement, and why your reliance, is justified given that.
And you're talking about the GAO report, Your Honor?
The GAO report and for that
So-
matter, what the Deepwater Horizon Commission reporting found.
Right. So on the amendments, Interior did do so Interior said in the supplemental EIS, we're relying on the information that we have now, and these proposed rules to amend the 2016 rules aren't in place. Later in the process, toward the end of the process, Interior said we have more information. So it gave another look at the amendments to the 2016 safety rules in response to a letter from plaintiffs, from one of the plaintiffs, and said, we'll take another look at this for NEPA purposes. But their conclusion was that the amendments to the 2016 safety rules didn't substantially change the environment, didn't impose any significant environmental impacts. That's at JA 1072 to 1076. So that was, so it sorry, Your Honor.
What about enforcement issues?
Yes. So on enforcement, so Interior did consider and address the safety agency's role. The safety agency's role, this is BSEE, BSEE is the acronym for the agency, but the safety agency's role doesn't kick in until the third and fourth stages of the leasing process. But Interior did analyze the safety agency's role at this leasing stage in these EISs. And Interior's conclusion, and this is at JA 1022, is that the safety agency did have a rigorous inspection program. So certainly the GAO report says that there is work to be done. That's what the district court found, that there is work to be done. There are specific areas where GAO, which is a government auditing agency, identified areas for improvement that the agency needed to focus on, that the safety agency needed to focus on. But I think the report, plaintiffs suggest that the report shows that the agency can't do any enforcement, or that it's incapable of effectively enforcing the law. And
none of these EISs engages with that report, right? The first EIS says we'll deal with it later. And I'm sorry, I've forgotten if it's the second or the third, but the later one says this is outside the scope of our inquiry at this stage.
That's correct, Your Honor.
If there's a concern about systematic failures in an agency, that's just as relevant to the global decision, the 10 versus 0 decision, as it is to whenever it is you come to the point of making a final decision on any individual lease.
I would agree with that, Your Honor. And there's some tension between what Interior says, as you point out, in the 5-year program EIS and what it said in the supplemental EIS. Interior said, we'll take a look at this. And then when it reached the supplemental EIS, it said that it's outside the scope. I guess what I would say is the Interior's NEPA obligations. So Interior involves a lot of line drawing, and at some point the agency can't analyze every single element of every single decision that it's making. It has to decide where to draw the line. It decided to draw the line at, we know that the agency is going to enforce the law, and we can also assume that when we put conditions on leases, when we
it's a question of degree, and normally you would just invoke the presumption of regularity and move on if you address it at all. But I mean, this does seem like a pretty significant concern that's been raised. And you know, there's always a question of line drawing about you have to respond to major concerns, but not every little tiny concern. This seems like it's closer to major.
So I agree it's a question of degree, and if you know that you have to look at you can read the GAO report several ways. So I would point to counsel for plaintiffs pointed to several pages. I'd point to JA 433 to 435, as pages where the agency says, look, where GAO says that the safety agency has made progress. It has taken steps to address some of our prior concerns, but it has more work to do. So it is a question of degree, and I think in these circumstances, the agency is entitled to deference on its judgment that this is where we know that this is their judgment, that this is outside the scope of their analysis.
Yeah, except, I mean, you'd have a somewhat stronger case if they had said, we've looked at this, it's a question of degree. The report says they're making progress. Now, that's a different case from what we have, which is the agency saying, oh, we're just not gonna tell you, we're not gonna say anything about the report and the progress or lack of it.
I would agree with that. I would go back, though, to the basis for Interior's conclusions that the environmental impacts here would be negligible to minor. That's the ultimate question here. What are the environmental impacts from leasing? And Interior's
wasn't one of those conclusions that the safety agency would be enforcing these requirements? I mean, that's my concern with the safety agency point, is that it appeared that from the beginning, the agency itself was invoking in many different places the safety agency and its role and what it would do in coming to the determination that we're not going to have serious environmental impacts. So then when the critique comes, yes, but look at this report, it seems incumbent upon the agency, if for no other reason than its initial reliance on the safety agency, to engage with it, as Judge Katsas says. So I'm a little concerned about this. And then might you also speak to if it turns out that the court finds that this aspect or any other is a reversible error, and that the agency does have to go back and address this, what do you say about vacatur or not under these circumstances?
Well, I think the agency did talk about the role of both the safety agency and BOEM, the other agency, in future lease sale stages, and certainly those are an important role. But the agency also was looking at what it requires within lease sales and within permits and plans, and that is stipulations and conditions of approval that tell the leaseholders, that tell the companies what they can and can't do. And part of what Interior is doing here is reasonably relying on the fact that parties are going to comply with the requirements that are in their leases, that are in their plans and in their permits. Certainly the safety agency plays a role in backstopping and enforcing and overseeing that. But the starting point for Interior's conclusion was, we're requiring mitigation. And the mitigation is by the companies, and that mitigation is going to go a long way towards ensuring that leasing is done in a safe and environmentally sound way. And Judge Jackson, turning to your question about remedy, if the court is concerned that the agency hasn't responded to the GAO report, I think that's the sort of area where the agency can provide more explanation if necessary. But that doesn't require, that's not the sort of serious error that requires you to go back to the beginning of the starting place and the drawing board. The agency should have an opportunity to listen to this court's concerns and provide a better explanation and a better analysis of that specific issue. And in terms of the disruptive nature of vacatur, so we agree that setting aside agency action is the ordinary remedy in an APA case, but under Allied Signal, you look at the disruptive consequences. And I think this court's decisions in Vecinos El Bienestar and Oglala Sioux are examples of cases where this court has looked at the regulated parties, the leaseholders, their reliance interests, their economic interests. I would point to the declaration submitted by industry and relied on in their intervener brief at JA 149 as providing evidence of the sorts of economic and reliance interests that warrant not vacating these decisions.
I mean, we have done that, but we've also said that in a NEPA case, kind of remanding without vacature is pretty weak sauce. I mean, it pretty much kind of undermines. If NEPA is only a procedural statute and it requires a hard look at issues before you make a decision,
Judge Wilkins, excuse me.
Then
go ahead.
Then it seems to me that you're really undermining the principles of NEPA and the statutory scheme and purpose if every time an agency fails to really look at something that's not an ancillary issue. This is core. Like whether you're going to enforce the rules and regulations and policies and inspect properly is core to preventing a catastrophic spill. This isn't some ancillary issue. This goes to the heart of the decision and whether you should move forward. Shouldn't that be part of our analysis?
I agree. It should, Your Honor. The seriousness of the issue is important, and to be clear, Interior takes this court's views seriously, and if there is a defect in its NEPA analysis, then it will take a hard look at. We'll seriously study what the court has said, and also take a hard look at the NEPA issue. I will point out that, again, to contextually, at Joint Appendix 122, Interior did say that the safety agency has a rigorous inspection program. So Interior's view was that the safety agency would do its job. And if Interior thought that the safety agency was not going to enforce the law, it was not going to provide appropriate environmental safeguards as required by OXLA, then Interior would have said so. So, but if there's more work to be done, then Interior will take a hard look at that. And I would say, again, stepping back, we're looking at hundreds of pages of analysis on innumerable topics, 3 EISs, many years of study. So to say that Interior has taken a hard look at the environmental impacts of leasing, and it did that before it made its decision.
Judge Katsas, Judge Jackson, any other questions?
All set.
All right. Thank you, counsel. We'll hear on rebuttal from Ms. Hardy, and we'll give you 2 minutes.
Thank you, Your Honor. I'd like to address each of the 3 issues briefly in turn. So turning to the skewed no action analysis, Mr. Heminger points to the cumulative impact analysis, and that is exactly the problem here. The agency actually didn't compare what would happen cumulatively over the next 50 years if it did not hold these 2 lease sales compared to the action alternatives, if it did. And you can look at JA 939. The agency says that if we don't hold the lease sale, it will be postponed. So a separate analysis of the cumulative effects under alternative E, which is the no action alternative, is not considered here. You can also look at JA 239, which shows the cumulative impact analysis that the agency did. And it doesn't include the no action alternative. It also shows the differences in production over the next 50 years if you vary a lease sale by size. So if you offer all of the golf versus half of the golf, production is going to be substantially different over the next 50 years. it's equally as likely that if you have 8 lease sales instead of 10, there's going to be less bids, less leases sold, less production, less environmental effects. So the effects are going to be substantially different for that alternative. And the agency just didn't consider that possibility. That's the core of the problem here. Turning to the safety rules issue, the agency never said that based on the quantitative probability analysis alone, a catastrophic spill will not happen. And this court shouldn't put those words into the agency's EIS. They don't exist there. Instead, the agency numerous times points to the reforms because it said, like Judge Wilkins points out, a spill is always low probability, a catastrophic spill. But since Deepwater Horizon happened, the world has changed. And so the agency had to point to all of the reforms and say, we've made strides since Deepwater Horizon. So be assured a catastrophic spill is not going to happen again. And it points to the reforms time and time again. We point the sites out on pages 15 and 34 to 35 of our opening brief. It specifically points to the well control rules at JA 289, JA 634, and JA 1018. The agency doesn't cite specifically any of the other reforms in its EIS. Those were the critical pieces of change that the agency was repealing and that it relied on.
All right, your time has expired. So we'll take the matter under advisement. Thank you.
Thank you. Thanks, Your Honors.
We're gonna start.
Case number 21-1088, Bloomberg L.P. petitioner versus Securities and Exchange Commission. Mr. Bradley for the petitioner, Mr. Wyman for the respondent.
All right, good morning, Mr. Bradley. We'll hear from you.
Good morning, and may it please the court. I'm Keith Bradley, representing Bloomberg, the petitioner in this case. The SEC has approved a restructuring of the system for getting investors' reference data on corporate bonds. That's a major change, and the SEC's assessment of it is troubling. We talked about many different problems in our briefs, but here I'd like to focus on just two. First, the economic consequences, and second, the lack of evidence of an actual problem. First, the economic consequences. The SEC's decisions in this area are really about dollars and cents ultimately. Underwriters are going to have to submit data to Finra accurately and in a short time frame. SIFMA, that's an association representing investors and underwriters, told the SEC that compliance would be difficult, if not impossible, in many circumstances. The order doesn't even discuss that concern. Instead, the SEC simply asserted that the cost is small enough compared to the benefit because underwriters are already providing their data to data vendors. What happens today is an iterative process in which vendors work with underwriters to organize the information, to check it and verify it and prepare it for traders. Under the new rule, an underwriter has to do that work for itself. It's as though because you hand over a bag of receipts to your accountant every year, the SEC thinks that it takes no more effort to prepare your own tax return.
And can you explain to me why this might be a substantial problem? I mean, just looking at this from 200,000 feet, I'm struck by a couple of things. One is, it's just very hard to believe that in the digital age, it is really that hard for people who want to sell bonds to disseminate to the market really basic information. I mean, some of these data fields are things like the interest rate, the number of payments per year, the yield date. I mean, people make fortunes buying and selling stocks based on information flows literally in microseconds. And I mean, the idea that it's just an insufferable burden to disseminate data about when the bond is going to become due, it just seems hard for me to fathom.
So a couple of points, Your Honor. First is bonds are different from, you're right about stocks. Bonds are different in many different ways. And we're not talking about the ongoing flow of bonds whatever trading might happen in the secondary market over the course of
No, I understand, but
Right.
primary market.
We're talking about the data. Yeah.
Go ahead, sorry.
I apologize. So what SIFMA said is, look, we've got multiple bonds coming out at the same time. Things are changing up until the last minute, and it's hard to get it out as you have required it, like before we do the very first trade. This is actually different from what the committee had actually recommended, which was make sure you give it to Finra before you give it, at least no later than you give it to a reference data vendor. What Finra is requiring is a certain degree of speed and obviously what comes with that accuracy. Second thing is, we're not claiming that it is insuperable. Our point is that there is a system in place. People are getting data. And in fact, I would say that there's a fundamental illogic here, because the SEC has found that the underwriters are all giving their data to data vendors already, which makes sense.
But there's also record evidence that the market is not as efficient in terms of the dissemination of data because you don't have a large percentage of people participating on day one. And so why isn't the SEC entitled to look at that? They convened an entire committee of people who from different aspects of this market to address what they think is a problem. So I guess I'm a little confused as to your suggestion, both here and in your brief, that there's really nothing to see here in terms of the initial concern.
So one thing that I find really striking here is that in principle, this is all in service of investors and traders and bond issuers to make sure that the investors and traders have access to the data that they need. The investor and trader representatives in this case opposed or were dubious of the proposal because their reaction was, we don't see why this would be particularly more effective or efficient than what we have today. The record evidence that you're referring to is record that some data vendors have trouble getting access to data, or some of them find their process inefficient. Everybody agrees that Bloomberg is the largest in this market, and there is no evidence that its process is inefficient. There's also no evidence.
I'm asking about the statistical evidence about the numbers of trades that are actually occurring in this market, not just whether the data vendors themselves feel like the non-Bloomberg data vendors feel as though they are getting information from the underwriters, but sort of a bird's eye view of how many people are participating in this market from the beginning and what are the impediments to them being able to do so. And my understanding, and I'm certainly not an expert in this area, my understanding is that that there was data that indicated a fairly low percentage of first day, first hour trades. And that at least some information before the committee indicated that that was because people felt as though they were not getting access to the necessary reference data to enter and participate at that first stage. Am I wrong about that?
I believe so, Your Honor, and I want to talk about the statistics because that's very important.
Okay.
So far as I know, there is one piece of statistical evidence that purported to support this rule, and it is a graph that Finra submitted that purports to show, as you said, a certain gap in the timing of trading. Bloomberg responded to that to demonstrate that the apparent gap in that data is due primarily to sort of data selection issues, because there are differences in what, and this, so first off, Finra's data is entirely about trading by what are called alternative trading systems. This is a certain kind of platform, trading market. There is and has been a, I don't want to call it a skew, but those trading platforms trade more large bonds than small bonds. That is largely what's going on in Finra's data. It is an artifact of the data, which Bloomberg demonstrated with its own statistical submission, And the SEC responded to this. The SEC considered that sole piece of statistical evidence and said, we're throwing them both out. None of this is really relevant because the problem here is not about alternative trading systems. It's about others. So, and aside from that, Your Honor, I'm not aware of any statistical evidence that shows a gap in access, shows an inefficiency, shows a lack of availability of data, any statistical evidence that supports this proposal.
So let me ask you, is it possible under the current system for an underwriter to disseminate the information about its bonds to the entire market by giving that data to only one vendor? Or do they have, like, is there a world in which they can do what they want to do, they, the underwriters, meaning control the data, make sure it doesn't get inaccurately reported to a bunch of different people. We want to give it out one time. Can they give it out one time and reach the entire market under today's rules?
I have to be honest, I don't know, and the record doesn't say. I believe, so there's evidence, for example, of an underwriter that says they give their information only to Bloomberg. And they do that because Bloomberg is the most accurate source. I suspect that they would do that because they think also they can get to the entire market. And there is conversely no evidence that of any investor or trader that has ever lacked access to information about any particular bond. So I think that what you asked.
But they can only get to the entire market if the entire market subscribes to Bloomberg's service, right?
If that were the case, yes. If they only give it to Bloomberg, that's right. Now, if they gave it to two or three, maybe they would get
for free. That's just how one of the ways Bloomberg makes its money, right?
We are certainly, I acknowledge we're here because we value the revenue. Bloomberg values the revenue. That's why it has standing here. But this is ultimately the court should be concerned about the investors and whether
and that's why I'm asking this question. I'm asking the question because what I understand the problem of asymmetry and the concerns about inefficiency to be is that on the first day of trading, everyone in the market does not have access to the same information. A lot of people have access to the information because Bloomberg is such a dominant player in this market, and Bloomberg allows for people to have subscriptions. And so if you subscribe to Bloomberg, you're going to get a lot of it. But not everybody subscribes to Bloomberg. And I understand the problem to be that creates an asymmetry in the market in terms of who has the information to be able to participate. And so the rule was designed to deal with that. The rule was designed to set up a system to make sure that everybody gets at least certain basic elements with respect to all of these trades. And of course, Bloomberg can still continue to operate and give more and give better and give easier or whatever. But sort of, I was thinking about this like in the law, our opinions are up on our website every day, all the time. But then there's also Westlaw and Lexis, and those services, you subscribe to them, and people still do subscribe to them, even though they could just come to my website, our website on the court, and get the opinion. So this is essentially the agency putting the data up on the website, letting everybody, the basic core, get it. And I don't understand why that's not okay under these circumstances where they see this problem, access being limited.
I see I'm out of time, but I would love to give you a response to that because there is a response. Please
feel free.
So a couple things. One is in Finra, so if an investor, Finra has its system, an investor that wants those data will have to go and buy them from Finra. That's not different from buying them from Bloomberg. It's just replacing one source for another source as far as that goes. And the investor representatives in this proceeding were generally concerned that the Finra version will be actually more expensive and less efficient. There's no evidence that it will be
Let
better.
me just stop you there, because don't we see a difference insofar as Bloomberg might not have everything? I mean, in the world in which underwriters do only give it to one source, most of them, 90 some odd % of them may give it to Bloomberg, but we do have some who are giving to other vendors. That's why a person today would have to cobble it together from Bloomberg and these other vendors. So it's not a one-for-one trade between paying for it from Finra versus paying for it from Bloomberg, because Finra is going to have more information, won't it? It has the universe. Well,
respectfully, Your Honor, there actually isn't evidence in the record of bonds for which Bloomberg doesn't have the information. So this is a hypothetical that there would be some set of data. Like, there actually is not evidence of that. But if I could come back to your PACER analogy, there's a critical difference. PACER, getting support, getting your opinions is free to the public. And why is it free? It is supported by tax dollars. It is supported by fees paid by litigants. It's not free. It's just that there's been a public judgment to support it in that way. This Finra service is also not going to be free. It is going to replace a system that already exists, which, if that is a cheaper and more efficient way, that would be one thing, but the SEC expressly refused to assess whether it will be.
Yes, but that argument I find troubling as well, because those are the same thing. In other words, FINRA is a government agency. I never understood the argument that you're making that the government agency has to assess the cost to itself of setting up a system. That's not really the way we ordinarily do this. Congress has made a determination that the agency needs to take steps to enforce the Exchange Act, to promulgate whatever system is necessary to ensure that the Exchange Act goals are satisfied. And the cost of doing that is sort of baked into it, just like the cost of the court setting up a PACER is part of being a government entity. So I don't really understand that argument in that sense.
Let me explain that as well. So one thing is that government agencies, when they do cost benefit analyses, they do assess the costs to themselves, because when they take on a new thing that's going to cost the public more money, and we'll be happy to submit some examples of that. Second thing is that the FINRA is not the government. The SEC's argument is exactly the opposite, that the SEC shouldn't have to think about the costs because FINRA is private, which is true.
What do we know? What do we know about how FINRA is funded? Is it primarily through government taxes and appropriations, or is it through dues imposed on members? The latter.
It is through two sources: dues on members and fees for services, such as the fee it might charge for this.
And do you have any authority one way or the other on the extent to which a cost benefit analysis has to incorporate costs to the government, just assuming for now that we treat FINRA as a government regulator rather than a private regulated party? I didn't see much in the briefs one way or the other on that question.
I think there is not much in the briefs on either side. I don't, off the top of my head, have cases on that for the government, but we'll submit some. It is routine for agencies to think about their own costs, though. So we'll find something.
A little bit, but that's a little bit different from saying that they have to, either as a matter of APA law or under, I think it's Section 3 of the 34 Act.
Agreed, it is different, but I will say that, especially for FINRA, this is, as we just said, this cost is coming from somewhere. It's coming out of broker dealers who are the members, and basically every broker dealer has to be a member. So it's going to be dues to members or it's going to be fees to subscribers. It's going back out to the market participants. So, so it seems to me that as a matter of, this court's logic in cases like Business Roundtable and Chamber of Commerce, to refuse to think about that cost means that you are just sweeping an important aspect under the rug.
Can I ask you,
is it
were
really
those?
being swept under the rug? Because once Finra determines what it's going to charge for this, there will be an opportunity for Finra members to object, because they could say, you are taking some of our dues to subsidize this activity, and we think that that's improper. Or the traders or investors who would have to pay the fee to access the data could say this fee is too high, or this fee is much more than what we would charge, than what Bloomberg charges for the data, and so this is really inefficient. All those arguments are on the table later, right?
Not quite all of them, Your Honor, because, and this is in fact the SEC's interpretation of the Exchange Act. It says that that decision is about the allocation of charges. The rule under which Finra undertook that it's going to build the system and operate it, take in the data and disseminate them, is the rule that the SEC approved in this case. This was that decision. Later on, there can be debate about how the cost gets parceled out amongst, whether it goes in fees to subscribers or it goes, but the fact that Finra undertook that cost, that has happened. And if the SEC decides,
can't we say that really assessing that at this moment is not really ripe for us to decide, since we don't know what that is? Isn't that the better way of dealing with that than saying that what the agency has decided so far is arbitrary and capricious? And if we say that making that determination right now is not ripe, then that would necessarily preserve it for you or others to make that argument at the second stage, right?
Well, to be candid, Your Honor, this court might never have the opportunity for it, because as you may know from previous decisions of this court, if the SEC looks at gets a fee proposal and then takes no action on it, that is not reviewable. So as far as this court's actually looking at it, this is possibly, in fact, likely the only moment. But in terms of whether it is right, this court has said again and again.
Just to respond to that, you're telling me that Finra couldn't petition for to revoke the rule or petition for rulemaking or something, and then if the SEC denies that wouldn't be an avenue to get court review? Or that you're saying that that's not possible?
So as far as a fee rule goes, the process is that Finra will propose a fee rule. It is entitled to make that rule immediately effective. And if the SEC doesn't respond, and then the SEC, you're right, we could petition the SEC to undo the rule that's in place today. But it's easier to review the rule the first go round, which is exactly what we're asking. In terms of whether it is ripe, this court has said again and again that just because you don't know exactly what the cost will be is no excuse for not looking at it at all. I think we can all agree that the amount of the cost is part of the economic consequence of this.
Yes, and so to that extent, the rule is ripe for consideration. But my question, I think, about this is, weren't the broker dealers on the initial committee that looked at this? Weren't the investors a part of it? You're now suggesting that the SEC has done something inappropriate by not considering the fees and the ultimate cost that will impact those groups of market participants, that they were involved in the process. Everybody knew there was ultimately going to be a fee, and they unanimously agreed to this proposed rule. So I guess I'm just confused as to why it is that you are suggesting that the SEC did not act adequately in its consideration of the fact that there will ultimately be a fee, and its determination that it will control those costs eventually down the line.
So your point about the committee's consideration is a very interesting one, Your Honor. First thing is, the recommendation that the committee made is actually different from what the SEC approved in important ways. For one thing, the committee proposed something about the fees that actually really wouldn't have been lawful under the SEC's interpretation of the Exchange Act. And for another thing, the committee proposed a different timing that would have made things much simpler for underwriters. Second thing, though, is that while the committee was universal on that actual proposal, one member of the committee wrote to the SEC during the comment process to say, the recommendation they were unanimous on. One member wrote into the committee to the SEC in the comment process to say, the actual proposal is a bad idea because you shouldn't put this in Finra's hands. Another economist that the SEC relies on very heavily says, this is going to be a good thing so long as the data are free, which is sort of magic thinking that, again, sweeps that cost under the rug. Investors, then referring to the Credit Roundtable, commented to the SEC that, yeah, we would love more data and more transparency, but the initial cost that that Finra has proposed, at that price, it's not worth it. So all of which are examples of why it's not enough just to say we had a committee and they told us this. The SEC has an obligation to think about the comment record and the evidence on its own.
But if FINRA comes up with the price and everyone, lots of people object, the SEC at that point can suspend it, and this program basically, is over, right? Unless and until FINRA comes up with a better fee structure.
So I think what would happen if the SEC disapproves the fee rule, the fee when it happens, is that the rule that we have today stays in place unless the SEC takes further action. The SEC is empowered to abrogate one of FINRA's rules. They could do that, but it would require that active decision by the SEC with all of the appropriate analysis of that. And then again, the market, the underwriters, the issuers, the traders are going to have this out there that there's a system coming, we have to comply with, FINRA's going to build it. And in the meantime, FINRA will have incurred this cost. At some point, they're going to have to figure out what it costs to build and run a system. This was really the time to do it.
Would it make sense for us to hold this case in abeyance until we get the fee proposal, and then you could, if you chose, file another petition at that point, or we decided at that point?
Well, I would rather that you vacate the order that's at issue here, but I want to remind you, Your Honor, that most likely we can't file a petition, because if the SEC accepts the fee rule, that's something that this court has said it can't review. So, which brings me back to, this is our shot to get review of the economics here.
I still understand. I still don't understand, Mr. Bradley, why this is your shot to get review of the economics, because that aspect of this rule, which is totally promulgated, setting up a system, it says there will be fees and the fees will be evaluated at a later date. Why don't you have the opportunity, once the fees come into effect, to say something about it at that point? Because under the Exchange Act,
under a Dodd-Frank amendment to the Exchange Act, if the SEC lets the fee rule stand, that is not reviewable. If the SEC rejects the fee rule, FINRA could challenge that, but nobody can challenge the SEC's decision just to let the fees go into effect.
But there can be a separate, isn't there judicial review of the fees apart from this particular dynamic?
No, there is not. And we cite some of these cases in our brief, but this is the Net Coalition line of cases which have closed off. And it's not this court's fault. I mean, Congress made that decision, but those avenues of review have been closed off.
But just to be clear, it didn't close off, I didn't think, your client's ability to file a petition for a rulemaking to set aside the fee.
I assume that is correct, that we could file a petition for that, but I'll point out that the SEC's assessment and this court's review of that is very different. This court's review of the decision, shall we have this system, is whether it was arbitrary and capricious not to have, to have this system. If we file a petition, the SEC says no because we have the other priorities. The review of that, of the denial of that petition, is a very different animal.
I understand that it's a different type of review. It's kind of a different standard of review, but that's different from saying that it's unreviewable.
Well, so the SEC's decision to leave the fees in place is unreviewable. What you're suggesting is that after that happens, we would be able to petition the SEC to have it undo that decision. And that is something that I think this court, it's not clear whether we could do that and get judicial review of it because of what this court said in the Net Coalition cases. I would like to think that we could get review in that circumstance, but again, and you would be reviewing the decision, the SEC's decision to allow the fees and allow the system to go forward with that fee structure. That in itself would not be reviewable.
Judge Katsas, Judge Jackson, any further questions at this time?
Just one more quick practical question. From the perspective of the broker dealers, they obviously want to get information out to the market. They collect the information under current arrangements. They disseminate it through Bloomberg. Is there any reason to think it would be more burdensome or unattractive to them if that system were replaced by one in which they do all the same things, except then they disseminate it to the market through Finra?
Yes.
Why?
There are a couple of reasons. So first thing is, with respect to their transmission through Bloomberg, it is voluntary on their part. They are Bloomberg as the data vendor, and every other data vendor who does this. It's our job to do this in the way that is most convenient and efficient for the underwriter. We are doing. Bloomberg invests to make sure that it is easy for the underwriter. The Finra system, the underwriter is responsible for the accuracy of that and the timing of it. So there is a compliance and cost and a system building cost to get in the place where you could do that and operate that on an ongoing basis that is getting shifted from data vendors
from the vendors to the, okay. Thanks.
Are the underwriters joining with you in this opposition to the rule? I would think they would be able to speak for themselves concerning whether or not the shifting of costs is really a problem. And I'd understood that they were also in agreement, at least as represented on the initial committee, that this proposal was a good idea.
The committee, the court, neither the court nor I knows how the SEC chose people on the committee and whether they are representative or not. What I will tell you is that the trade association that is the largest representative of underwriters opposed the proposal. They are not petitioners in this case. We're the only one. They commented 3 times, which is kind of a lot for the context. And the gist of their comments was precisely, this is burden on us. Please don't do it this way. So these are the SIFMA comments that are in the joint appendix.
All right, any other questions for petitioners counsel? All right,
Second.
thank you, Mr. Bradley. You exceeded your time. We'll give you some time on rebuttal.
Thank you.
Let's hear from counsel for the SEC, Mr. Wyman.
Thank you, Your Honor. May it please the court. My name is Theodore Wyman, and I represent the Securities and Exchange Commission. FINRA has proposed to collect and consolidate a limited range of data from a subset of its own members for consolidated dissemination to the public. None of FINRA's members will be subject to the new rule opposed it, nor did the private subscription services who currently provide their own comprehensive data services to the public, except for petitioner Bloomberg, who seeks to maintain its entrenched superior access to this information. Yet Bloomberg points to virtually no evidence in the record that is even arguably at odds with the SEC's findings, nor any relevant evidence that the SEC failed to consider. In Bloomberg's argument, they put almost decisive reliance on the comments of SIFMA, which were certainly not at this degree of focus in the briefing. And I think if this court looks at SIFMA's comments, they don't support the argument that SIFMA contended this was difficult, if not impossible, to achieve. SIFMA certainly weighed in on the analysis of the rule and the proposal and was hopeful that the system would be more automated. They said that they were concerned that it would be challenging to do, and they hoped that FINRA would actually invest more in the system to make it easier for them to submit information. Of course, that's what they want. But what the commission determined is the cost relative to the current environment, that is what underwriters currently do in providing information to Bloomberg, there will be minimal cost. That's supported by the advisory committee, who actually contained several SIFMA members, had underwriters, had investors, had traders on it, 23 members from across the industry. And the advisory committee undertook its own investigation and gave its own views. And the conclusions that it found were that the underwriters were not concerned, including those on the committee. And of course, they haven't filed anything here or suggested that this would impose significant cost on them to comply. So that's simply not supported in the record. I think there's a few points that to respond to that Bloomberg just made. One would be that there's simply no problem in the market, no access problem, and that's not supported by the record. Well, that's not the case. I mean, Bloomberg concedes that vendors have data access problems. There's no dispute that those vendors have subscribers. Oh, sorry, there was an echo in Zoom. That vendors currently have subscribers. Other vendors provide services to customers. Ergo, those customers are not getting complete access. Now, the reasons why everybody doesn't subscribe to Bloomberg, we could speculate, but the fact is, everybody doesn't subscribe to Bloomberg, nor would that necessarily be a good thing if there were only one private supplier that monopolized the information. The fact is, there is a data access problem in the market. That's
Can
because—
I just clarify, Mr. Wyman? I'm just trying to understand your argument.
Yes, Your Honor.
So the data access problem that you are homing in on, and that apparently the record supports, is data access by competitors of Bloomberg.
Well, to be clear, Your Honor, that is the data access problem is ultimately by the market participants. Bloomberg concedes that the sort of intermediaries have data access problems, and so that is another piece of evidence that shows why this is occurring. But ultimately, it's about the data access problems faced by the market participants who get it through trading platforms and vendors ultimately. But it's just
statistical evidence. Mr. Bradley says there's only one piece of evidence that he identified in the record that speaks to the statistics of people entering the market, and that that's not something that the SEC could have or should have relied upon. Can you talk about that?
Sure. I believe opposing counsel was referring to the discussion about alternative trading systems, a form of e-trading venue. Ultimately, that's a subset, and there was an argument about whether that subset there's a data access problem for those platforms. But the commission ultimately determined that that data was inconclusive, and even if you accept that Bloomberg's argument that alternative trading platforms don't face this issue, there are other e-trading platforms that weren't addressed by that statistical information. And beyond e-trading platforms, the market as a whole, there's other participants in the market that had data access problems. As to whether there's statistical evidence as a whole, the record doesn't have statistical evidence of that nature on either side. So the commission conducted a qualitative analysis of the evidence that was before it. The views of participants in the market, who the advisor committee, who had 3 rounds of opportunity to submit comment. The commission took what was before it. In Prometheus Radio last year, the Supreme Court sort of reiterated a view that this court has said since Chamber of Commerce, at least, which is that an agency is not required to conduct its own empirical analysis, go looking for statistical information that's not submitted in the record. There weren't competing, statistical reports here. There was one-sided evidence that underwriters, that there's a data access problem among market participants. There was an explanation for that, which is that the intermediaries can't get the information. That's where the data vendor access problems come in. And Bloomberg concedes that the intermediaries for a lot of this information can't get data access. So, with that wealth of information, that was enough to make the judgment that, in fact,
Bloomberg also says, but everybody can have it. Just subscribe to me. Why are they wrong about that? I mean,
right.
As long as they're providing adequate, accurate information concerning these trades, and the vast majority of underwriters are actually providing their data to Bloomberg through systems that Bloomberg has set up to make it easy for them to do it. What really is the problem here?
Well, there's 2 points I would say to respond to that. The first is, if that were true, that would only support the notion that this rule is justified by the competitive benefits that it would bring, because it would increase competition in the data services market simply by Bloomberg's own admission. But I think fundamentally, in terms of what this means about data access, nobody disputes, Bloomberg doesn't dispute that there is a data access problem currently. That is, that vendors they don't dispute that other vendors don't have complete data sets. They don't dispute that those vendors, for whatever reason, have subscribers, and that those subscribers, ergo, do not get the full tranche of data. So if Bloomberg alone is the solution to this market problem, it simply hasn't solved it, because it is not providing universal access, whether that's because of the prices they charge or allegations of anti-competitive conduct which have been made. The commission didn't find that, but the commission didn't go into the reasons why Bloomberg has this dominant advantage, but they found or that some people are not getting this information by virtue of not subscribing to Bloomberg. But the fact is, people are not getting the information. There are people who subscribe to other services for price or whatever reasons, and they are not getting full access. And of course, people who don't subscribe to anything at all, they're completely shut out, because there's just no way for them to access this real core information. And that's the key here. There's no evidence. Bloomberg, I think, elides the distinction between the core evidence and the comprehensive services that are provided. The data vendors, they compete by providing comprehensive services with add-ons, analysis, a whole data set, and much more data beyond the 32 elements here. These 32 elements are just the gateway to access the market. It's the core stuff, the name, the interest rate, the maturity date, just this key stuff. And that stuff is inaccessible for many people. You have to, I guess Bloomberg's saying you have to subscribe to Bloomberg, but there's reasons why they don't, apparently, because not everybody does subscribe to Bloomberg.
Can you just help me with the basic conceptual question I asked your friend on the other side, which is, this is extremely basic information. Yes. No rational investor would ever buy a bond not knowing the maturity date or whatever it is.
Yes, sure.
The people who sell the bonds, the issuer, the underwriter, people in the secondary market, whoever it is, have every incentive in the world to disseminate the information.
Yes, Your Honor.
And in the computer age, massive amounts of information flow very quickly and at very little cost. So you put all those things together, it's just a little hard for me to wrap my head around why there's any problem here at all.
Well, I think it comes down to timing, honestly, Your Honor. I mean, it's both a matter of timing and, but the fact is that there's as the record shows, that there's a limited time between when this stuff is going up, when underwriters, they have to collect the data and manually input it to be able to send it out. and they have hours maybe before it hits the market. And so this information does get out over time, but just simply too late to make an impact for that really key heavy trading period when this trading first begins. But I think that goes.
Who buys the bond without knowing all this stuff and a lot more?
I think they don't. I think that's sort of the what this rule gets at is access to the market. A lot of people are shut out because they can't get in on that first hour of trading. They have to wait till later, or not. By the time they have access, they simply they missed out on that trading period.
Why
impacts the market?
Why wouldn't the underwriter want to blast this to everyone in the world to pump up demand and therefore price?
I think they. Yes, Your Honor. I think they do, and this is the way that now they can do it more easily is through their organization, Finra, which represents them. But under the current system, it's sort of an entrenched system where you have to put all the data in and you have to send it to different people, and I guess different vendors might have different systems, so you have to maybe put the data in different ways. The record showed that there was a risk of you have to redo it, and that created risk of errors by retyping.
Right, but I mean another explanation of what's going on here is system is very efficient and Bloomberg is just doing this well, performing the dissemination function well, which is why everyone uses it. And if it were just if the economic these huge cost issues or collective action issues like advertising what the interest rate on the bond is. Yeah,
Your Honor, I was surprised on looking into and getting into the record in the market that this was an issue, but it's supported by substantial evidence in the record that this is simply something that underwriters, they get it out to one person and they move on to other concerns in the limited time they have that day. So I think it's about the timing mostly and what the priorities are, and they're simply diminishing returns and risks of errors by blasting it out, whereas a centralized system like this really resolves that. And I think it shows why it would be not difficult for them to comply with providing this information.
What's your response to your friend on the other side statement that the underwriters objected to this proposal and think that it's a bad idea to concentrate this responsibility with FINRA?
Your Honor, I don't think that's supported by the record at all. I believe they're referring to SIFMA's comments, which were far less decisive and to that end than they're suggesting. The underwriters were represented on the advisory committee. They didn't file, individual underwriters certainly could have, filed comments on their own. They could have opposed it in this court, and they simply haven't. The SIFMA has simply, obviously they want the best possible system, but what they've asked actually is FINRA develop, more automation, more make the system even easier for them to comply. But that doesn't mean that they oppose the concept of this, and that's simply not supported by the record. That charge.
Does Bloomberg have a reason to be concerned that, based on the assumption that underwriters only want to get this out accurately to one person and then move on, consistent with this new proposal, they will give it to FINRA alone? And therefore, we will have less competition ultimately in the market at the reference data vendor stage, that Bloomberg will lose, the other vendors may lose because everybody's just going to go to FINRA.
Right. Well, Your Honor, a couple of points. There's no evidence in the record that there's a competition in a specific market for 32 pieces of core information. The competition among vendors is at a much higher level with comprehensive databases, comprehensive products to parse that information, and so I think Bloomberg's argument ignores that vendors will be able to access information from FINRA and incorporate it into their own offerings. This is not something where FINRA market participants are required to go to FINRA, and vendors will be allowed under the terms that they will be allowed to take that information, feed it into their own system, and then provide their own comprehensive system that at least has that gateway key 32 pieces of information that lets sort of everybody get access. So I think the commission found ultimately that this is very well could increase competition by allowing more vendors, decreasing the barriers to entry, allowing them to sort of get the bare minimum you need to really compete. The commission also found that even if the information ultimately the underwriters don't provide it to Bloomberg which it found is possible that they will continue to do that because they're going to be providing other information beyond the 32 pieces of information that are here, and also updates over the course of the corporate bond. They're still giving information to Bloomberg. It doesn't make sense really that they would just cut out 32 pieces of information just because they already provided it to FINRA. But even assuming that, the commission said, even if that happens, it'll be minimal burden because this information will be available from FINRA. They're pricing it as a utility with a cost basis. That price will be reviewed for reasonableness later by the commission. And Bloomberg, contrary to what Bloomberg suggests, there will be an opportunity. This court in NASDAQ last year in the NASDAQ case rejected the claim that there will be no judicial review available. It'll be, they could, as Judge Wilkins pointed out, any party can petition this for rulemaking, the commission, and if it's rejected to change the fee, then it would go to this court. And
so you don't see any problem with the deferral of the fee consideration as Bloomberg sets it up? And I mean, do we have there? One could conceive of it as maybe a ripeness problem, but I'm struggling to see why that's so. And so, can you speak to that aspect of this?
Yes, Your Honor. The proposal under review is a reporting requirement. I mean, it's a reporting requirement to get the data from the underwriters with the view of creating a system to distribute the information and charge a fee. And the commission conducted analysis as required by the statute of whether that system, a fee-based system constrained by reasonableness and commission review later, would be as consistent with the Exchange Act. There's no requirement that the future fee to be proposed be included in this initial rule. There will be a second stage for that. But even if it were here, nothing would stop FINRA from proposing an amended rule. FINRA could have made the system free now, and in a year come back and said, under the same process, 19b3, said, now we're going to charge a fee. This is Congress's system. Congress, it used to be that, there would be pre-launch review of fees, but Congress changed that. And the system it created in 19b3, it says the establishment of a fee or the amendment of a fee is through this, can be reviewed, can be proposed through this process that would be later. So there's really nothing for the court to consider now in terms of fees because the current proposal doesn't alter, amend, otherwise affect the fees charged by FINRA. And so it's simply not.
Don't you have an obligation now to consider economic impact cost of this agency action?
Absolutely, Your Honor.
And it seems like it's not, if you imagine that FINRA stands up a system that they're not wasting cost, it's efficient. They do it as best they can. And therefore, under normal utility principles, the costs could appropriately be passed on. But it turns out to be more expensive than the Bloomberg system, right? Under normal cost without compensating benefits or whatever, right? Under normal cost benefit analysis, if those assumptions are right, you should have rejected this proposal now. And the escape valve possibility that if they build their system wastefully, you won't allow them to pass on all the costs is not fully responsive.
Well, Your Honor, I understand the argument there, but I think it fails in a couple of ways. I mean, first of all, I think you would look to the statute, which does not require the commission to consider, the impact on a self-regulatory organization's budget, right? I'll get to the economic impact, but it's simply, FINRA could build this.
It's unclear. It's unclear.
Well, FINRA doesn't need to come to the commission to upgrade its computer systems. I mean, there's a whole budgetary system. I believe, and it's not on the record, that some of this is supervised in different ways by exams, or maybe there's different oversight, but they don't have to go by rule for every internal expenditure. And I think, obviously, in proposing this rule, they're going to be undertaking this cost. And I think you would look at what are the ways in which this could potentially impact the market, the economy as a whole. The commission looked at that, and the commission found that there's simply no evidence in the record that these costs will be externalized any other way than will be reviewed by the commission when in dues and fees proposals. I mean, that's what the Exchange Act says under Section 15A. It says you look at the way cost. I mean, there's no dispute that costs are relevant insofar as they are passed on into the market, essentially. through fees and dues. That would be the 15A analysis, and perhaps a broader economic impact. But there's simply no evidence here in the record. Bloomberg hasn't put forward any. Bloomberg says maybe it'll cost $1 billion and they'll have to be bailed out by the federal government, but there's no basis for that. So I think you would look to the record ultimately. And there's nothing in the record that suggests that this would be some enormous undue cost that would go beyond the bounds that would impact the market. It was simply an internal cost, kind of a usual internal cost that you wouldn't, I think would require evidence that, sort of a internal cost would sort of bleed outside of the normal budgetary process for a self-regulatory agency and kind of create this market impact. And there's just not evidence in the record to support that challenge.
How is Finra financed? I mean, it's got to be through dues or fees, right?
Dues and fees, Your Honor. And if dues and fees were ultimately increased because of this, that would be all dues and fees proposals are reviewed by the commission. And so, under the theory, I understand what you're getting at, to the extent of what if we reject that?
So the cost, the working assumption, if you put aside the $1 billion freakish extreme hypothetical, the working assumption is that the costs of building up this government alternative to Bloomberg is going to be borne by the broker dealers who are charged fees by Finra.
Subject to commission review for reasonableness. And again, has it complied with the statute? It can't be unjust and unfair. All the requirements of Section 15A apply. So that will ultimately be determined. And so I guess the case that Bloomberg is suggesting is, what if the commission rejects it? And so it's not passed along to the market, and it's only Finra keeps it internally. And that's really the limited set of situations in which Bloomberg is saying is sort of speculative here. But the reality is, there's not evidence that Finra's budget, whether they have surplus, whether they can afford this in the record. And there's no indication in the record that this would bleed outside of that to impact the economy in any other way.
And there's also the practical catch-22, which is the understanding from at least what people have argued, or that you all have argued, that we can't know the cost right now until we've built it out. So if the statutory requirement is that we take into account these costs up front, then this will never be done. Then we can never have a proposal of any sort that might result in costs, because we can't know until we've undertaken the project.
That's right, Your Honor. And I think Bloomberg might say, well, there could be estimates, but no, that's not in the record. The commission has to go with what's put before it. And Bloomberg had plenty of opportunity to say, building this kind of system costs, they could have submitted studies. Anybody opposing the rule could have submitted comments. And I think that's what Prometheus Radio, sort of holds last year, the Supreme Court case, which says, you've got to look at what comes in. And if the commission doesn't consider evidence that comes before it, then that's arbitrary and capricious, it's unreasoned. But if there's multiple opportunities for commenters to supply data, to supply comments and evidence, and nobody puts it forward, then the commission isn't required to somehow conduct an empirical analysis and find its own statistical information. It judges based on the record before it. And there was enough record evidence to show that this is not going to disrupt the market. Again, it's a much more global view of the impact on the market. And the commission undertook that here.
I'll ask your friend on the other side this question, but please answer if you know. Let's suppose someone wanted to just purchase the core reference data for new bond issuances from Bloomberg, and that's all they wanted. Could they buy that today?
Your Honor, I've thought about that internally as well. There's not record information, I think, on whether Bloomberg can provide that provides just that 32 data fields. But I think that's sort of the point. There's not any evidence in the record that there is a market for just the 32 fields. What the record shows is that the data vendors provide comprehensive services. And this is just a subset that allows essentially all vendors to provide comprehensive services with the bare minimum you need to access the market, which means that all subscribers to them will now be able to access this information. And also people who don't want to subscribe to the services, who only want those 32 pieces of information, could get it just from Finra if they wanted to.
When we're thinking about the question of what categories of costs need to be considered, should we think of Bloomberg, should we think of Finra as a government regulator, or should we think of them as a regulated market entity?
I think they are a regulated market entity. They're closely regulated, but they're a self-regulatory organization.
Because I would think, right, there's an interesting argument, I don't know the answer to this, that in doing a cost-benefit analysis, usually you focus on the costs and burdens, the burdens imposed on the regulated parties, as opposed to the burdens imposed on the government regulator. But you undercut that our potential argument for the SEC by saying in your brief that we should think about this category of costs not as costs by the government, but costs voluntarily incurred by the regulated, not regulating, regulated entity proposing the rule. And then you go on to cite Business Roundtable for this concept of self-regulation.
Yes, yes.
So,
Well,
I appreciate the candor, but that
I'm sorry.
even if you thought that pure government compliance costs are outside the cost benefit, I'm not sure these costs would fall in the category.
Well, I think the distinction is in the posture of the rule. I mean, in the typical case that I think you're referencing, the commission is promulgating a rule that says, the SRO has to do this, or someone else has to do this. Here, when the SRO proposes its own rules, the commission's review is a little bit different. Its role is a little different. We don't have authority to rewrite the rule to make it better. It's simply, is it consistent with the act? If so, we approve it. And in this case, although Finra is the regulated entity, it is a regulated entity, it is also the one proposing the rule for itself. And so in this context, I think it is comparable to a government agency taking on the cost, not because it's governmental or whatever, but because it's the one proposing the rule. It's choosing it voluntarily. So I think in that context, you would look at the fact that they are choosing to incur it voluntarily. And so it's not something that's being imposed on them by the government, by the commission through a commission rule.
If we think of FINRA as the government for these purposes, do you have anything more? I thought the briefs were thin on both sides on the question whether the cost benefit analysis has to take account of costs of the government in administering the program. You have anything more on that?
No, I'm not aware of that, but I do know that the overall analysis is about the economic impact. That's really the touchstone. What is the impact, the economic impact as a whole? And that may include cost benefits for regulated parties in cases, but it's really about the market impact. And here, the commission looked at the market impact, which doesn't really include FINRA's internal budgetary costs. There's no evidence supporting that as a negative impact.
Thank you.
Thank you.
All right. Any further questions, Judge Jackson, Judge Katsas? All right.
Well said.
Thank you.
All right. We'll give counsel for the petitioner 2 minutes on rebuttal.
Thank you. There's much to say, but I just want to touch on a couple things. First of which is, Judge Jackson, your catch-22. There's no business in the country that would undertake a project like this before figuring out the cost beforehand. FINRA certainly can do that as well. They just didn't tell the SEC, and the SEC was willing to accept that. Second thing is that this is not like Prometheus Radio Project. The critical difference is the SEC was reviewing an application. This is an adjudication, an application from FINRA for approval, and the SEC's regulations say that FINRA had the burden. So I want to quote you actually from a decision that the SEC made just a couple weeks ago, rejecting a rule from a rule proposal. They rejected it from an exchange for a new kind of fund. Neither the exchange nor the sponsor provides any data or analysis to support its assertions, so we have to reject it. That was the answer, should have been the answer here as well. There is no data, I agree, there's no evidence that this is going to be a particularly expensive system because there is no evidence at all, and that was FINRA's burden.
I'm sorry,
a moment
FINRA's
about the
burden,
under.
I just want to be clear. It was FINRA's
Yes.
burden to do what you're saying? It was
To
FINRA's
provide the
burden
evidence.
to
Yes,
establish
FINRA's,
that it would not be an exorbitant system.
to establish whatever the cost would be and support an analysis of all of the relevant factors that the commission needed to consider.
And that is
So it
because
was FINRA's burden.
and that's because it's a private entity, or because that cost was going to be passed through to its members? Because I don't see it in the statute. So the statute has a lot of factors that the SEC is supposed to consider when it's determining whether or not to approve these sorts of things. And as Mr. Wyman pointed out, and as I had observed earlier, I did not see anything in the statute about how will this impact the budget of the self-regulatory organization. How will this, what are the costs to the self-regulatory organization itself? And you would think that if Congress intended for that to actually be a consideration, it would be there, just like all the other things. So what is it now you're saying that the SEC was supposed to require FINRA to say in this regard?
I appreciate the chance to trace this through. Section 3F of the Exchange Act says that in a decision like this, the SEC was supposed to consider the effect on efficiency, competition, and capital formation, if I'm remembering the language correctly. The SEC and this court have long interpreted that language to mean the SEC has to think about the costs and benefits of the decision. In this case, if yes, the FINRA can go off and if it's doing something that doesn't require SEC approval for some internal operation, then of course the SEC doesn't have to think about the FINRA's budget. This is a case where the FINRA requires SEC approval because it is a rule change requiring underwriters to do something and saying that FINRA is going to provide this service. So right, that required.
3F is not the section I'm talking about, right? I mean, I thought we were in 15AB, where there are a list of requirements that the SEC needs to take into account in approving the rules of this kind of association. So first, we have to determine whether 3F is even triggered here. I understand there's case law that interprets this language to be about costs and benefits, but it seems like quite a leap, even if we say 3F is involved, and even if we say costs and benefits are required, to suddenly say that means that the self-regulatory agency's budget, the cost to the agency itself, is what 3F is requiring under these circumstances. Do we have case law that says that?
I am not aware of cases either direction about the budget of the self-regulatory organization. I don't think it's controversial that 3F does apply. It does say review of a rule of a self-regulatory organization.
Yeah, so I'm assuming that. Let's assume it applies. Okay. Let's assume we have cases that say it means right. Costs and budget, costs and benefits. The question right. is, why does cost and benefits include budget of organization in this way?
So the neither 15A nor 3F says, lists out the costs and benefits. You have to know what the costs and benefits are. You have to think about what are the practical costs and benefits in any given situation. Of course, they are not spelled out in statute. In this case, the practical effect is, I think we all agree, Mr. Wyman and I agree, I think, that the FINRA is funded from two sources. Its internal budget is not, does not magically stay internal. That is going to be a cost to the market one way or the other. So it is consequently, it is a genuine economic consequence. So it's not because the statute spells out, here are 15 economic consequences, here are 15 costs to consider. It says consider, effectively, assess the costs. And this is one of the costs. That's why.
All right.
And my points.
Yep. Can you just answer the question to answer, Judge Jackson, and then I have a different question. Were you done?
Oh, I just had one little thing to say, which is just about the burden. The burden that being on the SRO is not, on FINRA, is not from the statute. It is from Commission Rule 700B3, which says very clearly that FINRA has the burden to provide the evidence needed to support the analysis.
So that's what I was going to press you on, which is this is an APA case, right? It's done on a closed record. even if I were to agree with you that this is the kind of cost the agency should consider, it's still a pretty big leap to say that the agency has the burden of developing the record on this point. I mean, usually in a cost benefit situation, agency proposes some burdensome new rule. The regulated parties come in and put before the agency the evidence of all the costs, and then 3F requires the agency to explain why it should proceed. Here, you all didn't put in any evidence, unless I'm forgetting, that the cost of this would outweigh the benefits, right? So there's nothing in the record one way or the other on that point. So why does the agency not win under I don't know, I guess I would say just general APA principles? They don't have to address a problem that is not developed in the record before them.
So, Your Honor, there is it comes back to this burden. I agree, the SEC was not responsible to develop the record. Finra was responsible to develop the record. That is what the SEC's regulations say. And so what happened in the record was we said, this could be very expensive. You should make Finra tell you what the cost of it is going to be, and you should be worried that it is going to be too expensive. We were not, in fact, the only people to say this. Multiple commenters did. And as I said, Credit Roundtable said their original guess about the price they're going to charge, this is not going to be worth it. So under the regulations, the organization is supposed to write
once more, give me this might be important to me. So just give me that site. Where would I find the proposition that the burden of developing the evidentiary record on this point is with FINRA? Where would I find that?
That's 17 CFR 201, I believe it is. Yes, 201.700B3.
Okay.
And that is cited in both of the briefs.
And you made this argument to the agency?
We did.
Okay.
And so the SEC routinely rejects rule proposals from exchanges and others for lack of evidence. They just didn't hear.
So you would have to say it was arbitrary and capricious. Given this rule of law, it was arbitrary and capricious, or there was no substantial evidence for them to conclude that FINRA had met its burden to show efficiency.
Yes.
Okay.
Yes. Well said.
Can you just answer quickly my question as if someone just wants this core reference data and that's all they want from Bloomberg, is there a process now where they could just obtain that and that only that from Bloomberg?
I regret to say that I can't answer that question either. I don't know their products enough detail to know whether you can buy just that sliver. What I can say is that the record shows that Bloomberg's product is available on the same terms, whoever wants to buy it. So we find it somewhat surprising. You know, the SEC says that there are investors and traders that are subscribers to other services and therefore can't get what they want. There's a fundamental economic illogic to that. If they want it and there's somebody willing to sell it, I don't know why they can't buy it. But in answer to your question, Your Honor, I don't know I don't know if Bloomberg sells a product that is just the 32.
Well, there's lots of things that I want that people sell that I can't buy. But at any rate, those problems are my problems and not yours.
Depends on the price. And of course, we don't know what the price of the FINRA system is either.
So, all right. Well, thank you. We will take the matter under advisement.
Thank you.
The Honorable Court is now adjourned until Tuesday, January 11th at 9:30 a.m.